Hello everyone. Welcome to our channel, where we delve into the fascinating world of law. Today we're embarking on a journey to dissect a landmark decision that's been handed down by the High Court of Australia. The case we're exploring is Vanderstock versus Victoria, made in 2023, and it stirred up quite a discussion in the legal circles. The case challenges the validity of Victoria's Zero and Low Emission Vehicle Distance-Based Charge Act 2021. The verdict has the potential to ripple through the fabric of fiscal federalism in Australia, shaking things up a bit. We'll be delving into the facts, the issues at stake, the rule, the application, the conclusion, the reasoning, and the take-home lesson from this case. This case has set a significant constitutional precedent in Australia's fiscal federalism. So buckle up and let's dig in. Let's first lay down the facts. In the spotlight is Victoria's Zero and Low Emission Vehicle Distance-Based Charge Act of 2021, commonly known as the ZLEV Charge Act. This act requires owners of zero and low emission vehicles to pay a charge for the distance they travel on specified roads in Victoria, effectively making it a tax on the use of such vehicles. The plaintiffs in this case, Christopher Vanderstock and another party, took issue with this. They challenged Section 7(1) of the Act, arguing that it imposes a duty of excise. Now, why is that important? Well, duties of excise are taxes on goods, and under Section 90 of the Australian Constitution, only the Commonwealth Parliament has the power to impose such taxes. So, the plaintiffs argued, the ZLEV Charge Act, enacted by the state of Victoria, was in direct violation of the Constitution. On the other side of the courtroom was the state of Victoria, defending the validity of the Act. They were joined by various attorneys general from other states, all of whom intervened in support of Victoria. The Attorney General of the Commonwealth, however, sided with the plaintiffs, intervening in support of their argument. The arguments presented by both sides were compelling. The plaintiffs argued that the charge imposed by the ZLEV Charge Act was effectively a tax on the use of goods which, under the Constitution, was a power reserved for the Commonwealth. On the other hand, the state of Victoria and the supporting attorneys general argued that the Act was a legitimate exercise of the state's power to charge for the use of its roads. The High Court was tasked with resolving this dispute. They had to determine whether the charge imposed by the ZLEV Charge Act was indeed a duty of excise, and therefore whether the Act was in violation of the Constitution. These are the key facts, setting the stage for a high-stakes constitutional battle. As we delve deeper into the case, we'll examine the court's decision, the reasoning behind it, and the implications it has for the future. But for now, we've set the stage, introduced the characters, and highlighted the conflict. The stage is set for a battle of constitutional proportions, a battle that will ultimately shape the future of fiscal federalism in Australia. Stay tuned as we continue to unravel the complexities of Vanderstock v Victoria, HCA 30. Now, onto the issues. At the heart of Vanderstock, v Victoria lies a critical constitutional question. It revolves around two sections of the Australian Constitution, specifically sections 51, 2, and 90. These sections delineate the taxation powers of both the Commonwealth and state governments, and are pillars of Australia's fiscal federalism. Section 51(2) empowers the Commonwealth Parliament to make laws concerning taxation, but does not explicitly exclude the states from doing so. However, Section 90 unequivocally vests the exclusive power to levy duties of excise in the Commonwealth Parliament. This case questioned whether Victoria's ZLEV Charge Act was in direct conflict with these constitutional provisions. The plaintiffs argued that Section 7(1) of the ZLEV Charge Act imposes a duty of excise, which would be a contravention of Section 90 of the Constitution. On the other side, Victoria contended that the charge was not an excise, but a user charge for the use of roads, something within the state's power to levy. This dispute highlighted the ambiguity surrounding the definition of excise. The Constitution does not provide a clear definition, and the interpretation of excise has evolved through various High Court decisions. Essentially, an excise is a tax on goods, but what constitutes a good, and at what point a charge becomes an excise, is open to interpretation. In this case, the court had to determine whether a charge levied on the use of roads by zero and low-emission vehicles could be classified as an excise. This issue is not just about a legal technicality, but it has significant implications for the distribution of power between the Commonwealth and state governments. A broad interpretation of excise could limit the state's ability to levy charges, while a narrow interpretation could enable the states to bypass the constitutional prohibition on excises. The decision of the High Court in this case was therefore eagerly anticipated, not only for its impact on the ZLEV Charge Act, but also for its potential to redefine the boundaries of fiscal federalism in Australia. These issues hold the key to the power dynamics between the Commonwealth and state governments. The decision in Vanderstock v. Victoria has set a constitutional precedent, clarifying the scope of sections 51, 2, and 90, and reinforcing the Commonwealth's exclusive power to levy duties of excise. This landmark decision will undoubtedly shape the future of fiscal relations between different levels of government in Australia. The main issue here was a critical one. It's not just about one law in one state. It's about the very fabric of our fiscal federalism in Australia. It's about the power balance between the Commonwealth and the states. So let's unpack this. The issue at the heart of this case, as we've mentioned, was whether Section 7(1) of the Zero and Low Emission Vehicle Distance-Based Charge Act 2021, colloquially known as the ZLEV Charge Act, imposes a duty of excise within the meaning of Section 90 of the Australian Constitution. Now, for those of you who have had the pleasure of reading the Australian Constitution, you'll know that Section 90 gives exclusive power to levy taxes on goods to the Commonwealth Parliament. This means only the Commonwealth, not the states, can impose taxes on goods. Why is this so significant? Well, it's because it's a key part of the balance of power between the Commonwealth and the states in our fiscal federation. It's designed to prevent the states from imposing protectionist measures that could interfere with the free movement of goods between the states, thereby maintaining a single unified market. But what does this have to do with the ZLEV Charge Act? Well, the plaintiffs argued that the Act imposes a duty of excise, and if it does, then it's a tax on goods, which only the Commonwealth can impose. So, the pivotal question was, does the ZLEV Charge Act impose a duty of excise? To answer this, we first need to understand what an excise is. In its simplest form, an excise is a tax on goods, but it's not just any tax on goods. It's a specific kind of tax that's levied at a particular stage in the distribution of goods. Traditionally, it's been understood to be a tax on the production or sale of goods. But here's where things get interesting. The plaintiffs argued that the charge imposed by the ZLEV Charge Act is a tax on the consumption of goods, namely the use of roads by zero and low emission vehicles. And they argued that a tax on consumption can also be an excise. This is a novel argument. It's not something that's been accepted before in our courts. But the plaintiffs argued that it's a logical extension of the principle that an excise is a tax on goods. After all, the consumption of goods is just as much a part of the distribution process as the production or sale. So this was the main issue. Does Section 7(1) of the ZLEV Charge Act impose a duty of excise within the meaning of Section 90? Or to put it another way, can a tax on the consumption of goods be an excise? It's a challenge to the traditional understanding of what an excise is. It's a challenge to the balance of power between the Commonwealth and the states. And it's a challenge to the very fabric of our fiscal federation. This issue cuts to the heart of fiscal federalism in Australia. It's not just about one law in one state. It's about the power balance between the Commonwealth and the states. It's about the free movement of goods between the states. And it's about the future of our fiscal federation. So, as we delve deeper into this case, keep this issue in mind. It's not just about the technicalities of tax law. It's about the bigger picture. It's about the principles that underpin our federation. And it's about the future of fiscal federalism in Australia. The court's task was to apply the constitutional rule to the facts. To do so, the High Court meticulously dissected the Zero and Low Emission Vehicle Distance-Based Charge Act. The Act, in its essence, imposes a charge on the distance travelled by zero and low emission vehicles on specified roads. The charge is computed annually, turning it into a debt payable by the registered operator to the state of Victoria. In applying the rule, the court had to ascertain whether this charge fell within the ambit of an excise. An excise, by definition, is a tax on goods produced domestically, particularly those considered harmful or non-essential. The High Court referred back to the Constitution, and more specifically to Section 90. This section grants the exclusive power to levy taxes on goods to the Commonwealth Parliament, prohibiting the states from doing so. The court then asked itself, does this charge act as a tax on goods? Is it an excise? In its analysis, the court considered the nature of the charge. It is not a one-time fee or a levy on the purchase of the vehicle. Instead, it is a continuous charge based on the distance traveled by the vehicle. It's a charge that accrues with the use of the vehicle, effectively turning it into a tax on the consumption of a good, the good being the distance traveled on specified roads. The court then looked at the payment of the charge. It is a debt that the registered operator owes to the state of Victoria. This debt, the court observed, is akin to a tax, which is a compulsory contribution to state revenue. The High Court, therefore, found that the charge imposed by the Act does indeed fall within the scope of an excise. It is a tax on the consumption of a good payable to the state, and it is levied on domestic products, zero and low emission vehicles. This application of the rule to the Act led the court to conclude that Section 7(1) of the Zero and Low Emission Vehicle Distance-Based Charge Act is, in fact, invalid, as it imposes a duty of excise, which is a power reserved exclusively for the Commonwealth Parliament. This application led to a groundbreaking conclusion. The High Court's decision has set a significant precedent in how we interpret and apply the concept of excise within the Constitution. It has broadened the understanding of what constitutes an excise and reaffirmed the exclusive powers of the Commonwealth Parliament in levying such charges. This case, therefore, has far-reaching implications for fiscal federalism in Australia and will inevitably influence future legislative drafting and judicial decisions. The court's conclusion was a landmark one. They deemed that Section 7, subsection 1 of the ZLEV Charge Act is invalid, as it imposes a duty of excise, which is a power exclusive to the Commonwealth Parliament. This decision marks a significant shift in the interpretation of fiscal federalism in Australia, as it reinforces the exclusivity of the Commonwealth's power to impose duties of customs and excise. Beyond that, it broadens the scope of what can be considered an excise, extending it to charges imposed at the point of consumption. This has ramifications for future legislation involving charges or taxes on goods, necessitating careful drafting to avoid constitutional invalidation. Essentially, the High Court has sent a clear message. The states cannot enact laws that effectively impose taxes on goods. This decision has set a new constitutional precedent. The reasoning behind this conclusion is worth noting. The High Court didn't just make a snap decision. Rather, they leaned heavily on precedent, considering previous rulings and their implications. They looked at instances where charges imposed at the point of consumption were deemed to be an excise. The court then applied this understanding to the ZLEV Charge Act. The court found that the charge, determined annually and based on each kilometre travelled, shared significant characteristics with an excise. It was an obligation, a debt payable by the registered operator to Victoria, and it was imposed on the use of goods, in this case, the use of roads by low or zero emission vehicles. This reasoning has broadened the definition of excise in Australian law. It's not just about the imposition of the charge, but also about when and how that charge is applied. This case offers a crucial take-home lesson. It's a significant milestone in the interpretation of Australia's constitution, particularly when it comes to the division of powers between the Commonwealth and the states. But more than that, it's a powerful reminder of the importance of understanding the nuances of our legal system and the potential implications of legislation. The High Court's decision in Vanderstock v. Victoria HCA 30 has broadened the scope of what can be considered as excise under Section 90 of the Constitution. This expansion of the term means that not only customs duties, but also any charge imposed at the point of consumption of a good can be considered an excise. This is a significant shift from previous understandings. It has wide-ranging implications for lawmakers, who now need to be mindful of this interpretation when drafting legislation involving charges or taxes on goods. But the implications of this decision reach beyond just the lawmakers. It also has potential impacts on businesses and consumers. Businesses dealing with goods, particularly those in the zero and low emission vehicle sector, need to understand this interpretation to navigate the changing landscape of tax and charges. Consumers too will be affected, as the charges they pay could potentially be influenced by this ruling. This decision also reinforces the concept of fiscal federalism, emphasizing the exclusive power of the Commonwealth to levy taxes on goods. It's a vivid reminder of the boundaries between Commonwealth and state powers, reinforcing the importance of maintaining this balance in our federal system. The case is also a testament to the power of the judicial system in interpreting and applying the Constitution. It highlights the role of the High Court in shaping our understanding of the Constitution and its implications on our everyday lives. In this regard, the case serves as a powerful lesson for law students and legal practitioners. It underscores the importance of understanding the Constitution and its interpretation by the courts. It provides a clear example of how the judiciary can shape the application of the Constitution, influencing not only the legal landscape, but also the economic and social aspects of our society. So, what's the key takeaway from Vanderstock v. Victoria HCA 30? It's a reminder of the complexities of our legal system and the potential implications of legislation. It's a call to lawmakers to tread carefully when drafting laws involving charges or taxes on goods. And it's a lesson to us all about the power of the judiciary in interpreting and applying the Constitution, shaping our understanding of the law and influencing the world around us. In a nutshell, this case is a stark reminder that the law is not just about rules and regulations. It's about understanding the nuances, interpreting the complexities, and navigating the potential implications. It's about recognizing the power of the judiciary in shaping our understanding of the law and its influence on our lives. This case has set a new constitutional precedent in Australia's fiscal federalism, and its implications are far-reaching. As we move forward, it's crucial to remember the lessons it offers. It's a reminder to lawmakers to be cautious and to all of us to be mindful of the potential impacts of legislation. So, lawmakers must tread carefully when drafting legislation involving charges or taxes on goods. That's all for today's deep dive into Vanderstock v. Victoria HCA 30. We've covered a landmark case that has significantly shifted the landscape of fiscal federalism in Australia. We've seen how the High Court, by ruling Victoria's Zero and Low Emission Vehicle Distance-Based Charge Act 2021 as invalid, has reaffirmed the Commonwealth's exclusive power to impose duties of excise. This decision has broadened the definition of excise and set a new constitutional precedent. In this world of law, every case, every ruling matters, and each one of them shapes our understanding and interpretation of the law. So, continue joining us as we unravel more of these fascinating legal narratives. If you found this content valuable, do like this video and share it with others who might find it insightful as well. And don't forget to hit that subscribe button to stay updated on our latest videos. Stay tuned for more intriguing legal discussions. Until next time.